Bexley Road in Bexley, England. A road where ordinary people live. A young man and his girlfriend are out for a walk.
Hold on a minute, Sid. What on earth was that?
It's in a devil of a hurry. Have you seen anyone run out of here?
Yes, he went that way.
What's in the car? Quick. Right. Just go on, Elsie. Keep quiet till we get a policeman.
Well, what's the matter? I've done nothing.
So tonight, on the 26th of September, the police are called to Bexley railway station, and a dark-haired man is accused of burglary. Fred Bennett and his girlfriend Elsie say they saw him run out of a house called the Haven. Davis, the man with the car, rents the house and says it has been broken into. The policeman cannot just take their word for it and arrest a possibly innocent citizen, so he asks them all if they'll come to the station for further questioning.
Well, if you don't mind, I must ask you all to come down to the station for further questioning. You two gentlemen come with me, and you, sir, follow with the young lady.
At the station, the policeman reports to the duty inspector and says that John Ludd, the suspected man, would not explain what he'd been doing. Mr. Davis is asked about his losses, but he's naturally not very clear. So the inspector calls the local criminal investigation department and asks them to assign a man to the case immediately. A few minutes later, Detective Sergeant Rowlands arrives, and the inspector sends him back with Mr. Davis to find out what, if anything, is missing. John Ludd, the suspected man, is asked to wait in another room. There is no doubt that the house was broken into. The burglar had apparently been prepared to take all the silver when he was disturbed by Mr. Davis' return. There had been a small supply of cash in the house. The detective wants to know how much it was and whether Mr. Davis knows the serial numbers of the notes. Mr. Davis can only tell him that there was £15 in £1 notes. So Rowlands passes on this information to the station as quickly as he can. The inspector decides to search John Ludd and asks him to empty his pockets. Apart from personal possessions, he has £15, 18 shillings and sixpence on him in cash. Every item is carefully recorded so that it can be returned to Ludd if he is found innocent. The inspector considers that there is enough evidence for a case against Ludd, and when Davis and Rowlands return, He asks Davis to sign the formal document charging Ludd with burglary. The inspector then reads the charge to Ludd. He warns him that he need not say anything in reply, but that if he does so, it will be written down and may be used in evidence at his trial. Ludd decides to say nothing. Now the initial fuss is over, and the suspect is locked away for the night in a police cell, the CID take written statements from all the witnesses while the incident is still fresh in their minds. They are also warned that they will have to appear at the local magistrates' court tomorrow. In England, most towns have a magistrates' court. They sit nearly every day, as in normal circumstances, a suspect cannot be detained for more than 24 hours without appearing before them. These courts summarily try petty offences and pass the more serious charges to a higher court if they think there's sufficient evidence to justify it. They listen to all the evidence, and it's taken down in longhand by the clerk to be used as a basis for further examination at the trial. In Ludd's case, they think there is sufficient evidence, and after consultation with their legal advisor, they remand him in custody until the next assizes. The chairman asks Ludd whether he can afford to pay for his own defense. Ludd says he cannot, and if he is prepared to swear to this in the witness box, he will be granted free legal aid. A few days later, the barrister, who will plead his case in court, and the solicitor, who will do the administrative work, visit Ludd in prison, listen to his story, and start preparing his defense. They are both willing to do anything legal to assist a prisoner, but they will not go outside the law to secure an acquittal. A date has been fixed for the trial. He will appear at the assizes, to be held in the principal town of his district during their next session in October. It is the 24th of October in Colchester, the county town. Today, 50 people, court officials, newspaper reporters, and members of the general public are gathered together to listen to the case of John Ludd.
And General Dale delivered to the jurisdiction of the county of Colchester. Go near and give your attendance. God save the king.
John Ludd, you are charged with felony, namely burglary, contrary to Section 25 of the Larceny Act 1916. And the particulars of the offence charged is that you, on the night of the 26th of September 1951, at Bexley in the county of Colchester, did break and enter the dwelling house of John Davis and did steal therein £15 in Bank of England notes. How say you? Guilty or not guilty?
Not guilty. As Ludd pleads not guilty, a jury of 12 men and women have to be called. They are ordinary men and women, chosen from a register of householders in the county. The clerk explains to Ludd that he may object to any juryman who he thinks may have reason to be unfriendly towards him, and that person will be replaced.
They are sworn, and your objection shall be heard. Bernard Hanson, Frederick Gamage, Patricia Lees, Henry Geddes, Diana Pine, Kenneth Cameron, Walter Doswell, Mary Cope, Alberta Wilson.
Ludd does not object to any of them, and they are sworn, each member making a solemn oath on his Bible that he will give an honest verdict.
According to the evidence. Section book in your right hand.
I swear by Almighty God that I will well and truly try and true diligence make between our sovereign Lord the King and the prisoner at the bar, and a true verdict give according to the evidence.
I swear by Almighty God that I will well and truly try.
So John Ludd will be tried by a jury of 12 independent and impartial people. It is they and they alone who will say guilty or not guilty. They are advised, however, on the law by the judge. He is a brilliant lawyer of many years' experience. Moreover, once a judge is appointed, he cannot be dismissed from office by the government. His decisions, therefore, cannot be influenced or questioned for political reasons. The clerk informs the jury of the indictment or charge, and the trial starts.
House of John Davis, and did steal therein £15 in Bank of England notes. May it please you, my lord, and members of the jury, I appear to prosecute. My learned friend, Mr. Mitford Stevens, appears for the accused. I am primarily concerned with the truth, and I will present you with the facts in this case. I will examine the witnesses who saw a burglar escape from Mr. Davis's house, and who later captured the accused at a railway station. I will also examine the police officers who investigated the crime. Call Detective Sergeant Rowlands.
Call Detective Sergeant Rowlands.
I swear by Almighty God that the evidence I shall give the court and the jury sworn between our sovereign Lord the King and the prisoners of the bar shall be the truth, the whole truth, and nothing but the truth. Detective Sergeant Rowlands, Colchester Constabulary, sir.
You, I believe, are the police officer who investigated the burglary at Mr. Davis's house.
Yes, sir.
Will you please tell the jury what you found there when you arrived?
The prosecution needs Rowlands to establish the fact that Davis' house was broken into. This is sometimes called formal evidence, but nothing can be taken for granted.
Doors and windows to find out how the burglar entered the house.
And what did you find, Sergeant?
I found jimmy marks on the back door, sir.
Thank you.
Davis.
Call John Davis.
Call John Davis.
Hold book in the right hand and say after me. I swear by Almighty God.
I swear by Almighty God.
You are John Davis, and you live at the Haven, Woodthorne Avenue, Bexley.
Yes.
Will you tell the jury what happened on the night of the 26th of September this year?
Well, sir, I arrived home from work at about 9:30 p.m. I went into the house and found it was turned upside down. I ran back to the front door and asked a young couple who were passing by if they'd seen anyone come out of my place. They said they had, so we jumped into my car and caught the men at the local railway station. Later on, Sergeant Rowlands came back to my house, and we found that £15 was missing.
Thank you. Did you have the serial numbers of the notes you lost?
Yes, sir.
If you didn't have the serial numbers, you couldn't possibly identify them, could you?
No, sir.
Mr. Davis, did you actually see the man that escaped when you arrived home?
No, sir.
Thank you, Mr. Davis.
So we got into Mr. Davis's car and chased him. We spotted him running towards the station. We caught him there. I recognize him, all right.
I see. So the man you saw leave Mr. Davis's house was the same man that you caught at the railway station?
Yes, sir.
Can you identify him from anyone in court?
Yes, sir. He's the man in the dock.
Mr. Bennett, is it not a fact that the front of Mr. Davis's house is badly lit?
Yes, sir.
How then can you be sure of the burglar's identity? Mr. Bennett, are you asking the jury to believe that although the nearest lamppost was 20 yards from the house, you were able to positively identify the man?
But I am sure, sir. That was the man.
but I couldn't see his face.
Miss Burke, you are standing in the witness box to give evidence at the trial of a man accused of a serious offense. Is the court to understand that you could definitely recognize this man without seeing his face? I suggest, Miss Burke, that you saw a dark-haired man wearing a light-colored raincoat running away from Mr. Davis's house. I would remind you that there must be some thousands of dark-haired men that dress in this fashion. But the prosecution called one more witness, the inspector who searched Ludd.
I searched the accused and found on him the usual personal possessions, and £15, 18 shillings and sixpence in cash.
Thank you. And that, my lord, and members of the jury, is the case for the Crown.
Prosecution has presented its case. The defense will now begin theirs. May it please you, my lord, and members of the jury. The defense here is an alibi. I will now call the accused, John Ludd. Will you tell the jury what happened on the night of the 26th of September this year?
Yes, sir. I went to a dog track at Stratton Park. I had a lucky evening and I won about £12. I had £3 on me when I started, so I finished up with about 15. I was running to get my train when Mr. Davis and Mr. Bennett jumped out of a car and grabbed hold of me. I usually go dog racing on Wednesday evenings when I can afford it.
Thank you, Mr. Ludd.
Mr. Ludd, can you tell the jury of anyone who saw you at this greyhound track?
Well, I have been trying to think of someone, sir, but it was a popular night. The place was full of people. I was just one of a crowd, you see, sir. I can't think of anyone in particular.
Thank you.
Call Mrs. Thelma Ludd.
Call Mrs. Thelma Ludd.
Hold the book in your right hand and say after me. I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give to the court.
The defense call the accused man's wife, as they think her story will influence the jury. Although generally a wife's evidence is not considered for obvious reasons to be very valuable.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Mrs. Ludd, will you tell the jury something of your husband's habits?
Well, sir, he's very keen on sport. He goes to football every Saturday in the winter, and he goes dog racing every Wednesday night.
At what time did he leave home on the 26th of September?
7:30, sir.
Was that the time he usually left to go dog racing?
Yes, sir, he always left at that time. You could set your watch by it. He usually went by train and got back around about 10 o'clock. I've known him bring back as much as £20 if he'd had a lucky night.
Your husband, you say, left home at 7:30. You, of course, didn't go with him and can't tell where he went.
No, sir. But I'm sure he went to the track.
How can you be sure, Mrs. Ludd?
I suppose I've no proof, sir, but he's been going for such a long time. I've no reason to doubt him now.
Thank you, Mrs. Ludd. May it please the court and members of the jury, this is the first opportunity that I have had to address you. May I remind you, first of all, that in England, a man is presumed innocent until he is proved guilty. Has the prosecution done this? They arrested a man found some distance from a burglary merely because he was running. Can an innocent citizen never run along a street except at the risk of arrest? Only one witness felt sure of the identity of the man, and even he admitted that the street was badly lit. The accused had £15 on him when he was arrested. Is that an unreasonable amount for a man to win at a dog track?
The fact that Mr. Davis lost £15 was mere coincidence. I suggest that the prosecution have entirely failed to prove their case. I ask you, therefore, to say at the very least that you are not satisfied that it was the accused who broke into Mr. Davis' house, and to find Mr. Ludd not guilty.
Do you propose to address the jury, Mr. Sedgwick?
If the Lordship pleases. Members of the jury, you have heard all the evidence, and I won't tire you by repeating it more than I must. I will only remind you of the following facts. The first witness to remember is Fred Bennett. He swore before this court that he recognized John Ludd. He was severely cross-examined by my learned friend, but he did not waver or express the slightest doubt. Secondly, we have learned today that Mr. Ludd spent the evening of the 26th of September at a greyhound track. Now, why didn't he tell the police or the magistrates that he spent the evening so innocently? Why didn't he tell them that the £15 in his possession was his just reward for knowing the right greyhounds to bet on?
Now, members of the jury, it is my task to sum up this case. I must first repeat the words of the counsel for the defense, and remind you that English law demands that the guilt of an accused man must be proved beyond all reasonable doubt. Now, what is the prosecution's case based on? It is based on three facts. Firstly, that Fred Bennett swore that the man seen leaving the haven was the prisoner. Secondly, that the prisoner had undoubtedly been found shortly after the burglary, running away from the scene of the crime. And thirdly, that he was found to possess a sum of money equivalent to that stolen. It may be that you will not feel absolutely sure of Fred Bennett's evidence, as he has admitted that the street was badly lit. If that is the case, then you must bring in a verdict of not guilty. And now for the defense. The prisoner offered his word, and his wife was sure he was correct when he said he spent the evening at a greyhound track and was running for a train when he was arrested. He said the £15 was mostly his winnings. You may wonder why the defense could not produce one witness who saw the accused at the greyhound track. Nevertheless, it is not the duty of the prisoner to prove his innocence, and the only question for you to decide is whether the prosecution has proved the prisoner's guilt. Therefore, members of the jury, will you retire and consider your verdict?
I swear by Almighty God that I will well and truly keep this jury in some private, convenient place. I will not suffer any person to speak with them, neither will I speak with them myself, unless it be to ask if they are agreed on their verdict, without leave of the court.
The jury retires, and the members are locked in a private room, one being chosen to act as foreman and to speak for them all. Here they can discuss the case for as long as they like until they reach a decision. But this decision must be unanimous. Either they all think the prisoner guilty, or they all think him not guilty. If they cannot agree, a new trial will be necessary.
7, 8, 9, 10, 11, 12. That's everybody. Shall we go back?
Members of the jury, are you agreed upon your verdict?
We are, sir.
What is your verdict?
Guilty, sir.
So the jury's verdict is guilty. Now the judge asks for Ludd's previous record, if any, to be read to the court. Until this moment, no one taking part in the trial has been allowed to know whether Ludd was normally an honest man or a criminal. The court now hears that Ludd has had 12 previous convictions for theft, robbery and burglary, and has spent 8 of his last 12 years in prison.
Kingsley assigned for burglary.
May it please your lordship and the court, I realize fully that the prisoner's record was not a good one. In fact, during the period 1936 to 1949, he spent more time in prison than he spent a free man. I would remind the court, however, that he has had no convictions since the one passed in 1947. He got himself regular employment in an insurance office when he was released. His employers have sent me a completely satisfactory record. I'm sure that the crime for which this court found him guilty today was an isolated lapse during a period of over 2 years on his citizenship. I feel sure, my lord, that if this man is given the chance, he will eventually become a worthwhile resident of this country.
Prisoner at the bar, you have been found guilty of felony. Have you anything to say why the sentence of the court should not be passed upon you?
John Ludd, you have been a perpetual source of trouble and an anxiety to your fellow citizens and the police for a number of years.
I sentence you to 5 years in prison.
A long sentence, but for a hardened thief. If this had been his first crime, the sentence would probably have been much shorter, perhaps probation, a second chance under supervision, with no prison sentence at all. But that is not necessarily the end of the story. If Ludd wishes, he can apply to the Court of Criminal Appeal for a reconsideration of his case, and then even to the House of Lords, if he can show that a point of law of exceptional public importance is involved. If he does so, all his costs will still be paid for him, since he cannot afford to pay for himself. Thus, in Britain, every man, even an habitual criminal, is assured of a just and honest hearing if he gets into trouble. He is afforded as much assistance and protection against an unfair conviction as any man in the realm.